Hello class. Today we will again continue with the topic we have discussed yesterday, that is patents. There is one very important concept in patents that is called as compulsory licensing. So let us see what is compulsory licensing. Compulsory licensing is when a government allows someone else to produce a patented product or process without the consent of the patent owner or plans to use the patented protected invention itself. So friends, here actually what is the general rule in case of in case of the patent? In patent, basically the patent holder gets the exclusive right over the manufacturing and selling of the particular product or a process. But there are certain exceptions, there are certain areas where the government, if it wishes, it can allow to manufacture even without the permission of the patent holder. What are those circumstances? Another important thing is, usually the general rule of patent is it is granted for a period of 20 years. But there may be certain exceptional cases, there may be certain emergencies, certain situations where the patent holder has to allow others to use that particular patented work before the completion of 20 years. So, this compulsory licenses can be available within a period of grant of patent within a period of 3 years. So here, after 3 years from the date of the grant of the patent, any person can apply for the compulsory license on following grounds. The first one is the reasonable requirement for the public with respect to the patented invention has not been satisfied. If the requirement, if the public feels that the requirement is not satisfied, then and there is a need of that particular invention, then anybody from the society can apply for the compulsory licensing of that particular invention. Point number 2, the patent invention is not available to the public at a reasonable, affordable price. Now friends, there are certain inventions, there are certain products which are very useful to the society, which are very useful not only for the richest but also for the poor. The richest can afford, but the poor cannot afford. So in such situation, this compulsory license may be allowed. Then lastly, the patented invention is not used in the territory of India. If a particular patented invention is used somewhere else from the place beyond the territory of the boundaries, then in that case also compulsory license may be invoked. Now, the Indian Patent Act 1970 authorizes who can give the compulsory license. It authorizes the central government to issue a compulsory license at any time after the grant of the patent in the case of point number 1, national emergency, extreme urgency, or case of public non-commercial use. All these situations may arise where the compulsory license may be granted by the Government of India within a period of 3 years from the date of grant of the particular patent. We will see certain examples of compulsory license. So, till now, only one compulsory license has been allowed by the Government of India, by the Patent Office, that is the Natco Pharma. It was issued to Natco Pharma in the year 2012, 9th March, and it was issued to Natco Pharma for the generic production of Bayer Corporation, that Nexavar, which is a life-saving medicine used for the treating cancer, that is liver and kidney. So it is medicine. As you know that treatment of cancer is very expensive. So this lab invented a particular medicine that is Nexavar, and this was very costly and it was not affordable, it was not under the reach of the commons. So here the government in the year 2012 granted compulsory licensing for the other manufacturers for the treatment of the cancer. Similarly, recently we all have faced the situation of pandemic COVID-19. So in this situation also, you must have seen that earlier it was given only to the people who can afford, who were able to pay for the vaccine. But later on, Government of India and many governments of different nations, they allowed the vaccine free of cost, as it was very useful to the public, and the disease was very severe, very serious. So to control this disease, to control this particular pandemic, many countries have are being allowed for compulsory licensing, where they are not required to take permission of the patent holder. The government allows, and the same can be continued without the general rules, without following the general rules of patent grant. Now, there are certain industries specifically which are given the authority for the compulsory licensing. Now, let us see what are those industries. So, basically, there are 6 industries who are authorized to get compulsory license if it is required. So, first is the installation and brewing of alcoholic drinks. Second, the cigars and cigarettes of tobacco and manufactured tobacco industries. Then electronic, aerospace and defense equipment. Then industrial explosives, including the detonating fuses, safety fuses, gunpowder, nitrocellulose and matches. As you know, all these are very hazardous and harmful to the public, so the government cannot allow anybody to manufacture this industrial explosive. Then hazardous chemicals, and lastly the drugs and pharmaceuticals, which is the list has been modified, and some guidelines, some policy has been issued in September 1994. According to that, all those companies who are coming under the drugs and pharmaceutical, they can go for compulsory licensing. I hope the concept of compulsory licensing is very, very clear to all of you. In this, we discussed what is compulsory license, what are the situations in which the compulsory licensing can be issued, and we have seen some examples of compulsory licensing, and now we have also discussed the various 6 industries who are given the permission for the compulsory licensing. So now again coming back to the patent, yesterday also we have seen in short that whenever a patent holder, a person or the inventor wants to apply for a patent, then what are the important documents, what are the information which has to be disclosed in front of the patent office for the application of the patent. So first thing is the information does a patent document provide means, first of all, whatever documents you want to furnish for applying for the patent, you have to mention all those documents, like documents related to your ID proof, document may be the specification, document may be any other thing which is required by the patent office. So you have to disclose all those things. Then what is the technology field of the invention? Means what technology you have used in your particular invention, whether it is a digital technology or whether it is any kind of process technology, manufacturing technology. It can be any technology with the help of which you have done that particular invention, that has to be mentioned. Then what technical problem is solved and how? Means what problem you have identified and what problem you are going to solve with that particular product or with that particular invention, that has to be mentioned. And what is the prior art? Prior art means if someone has done an invention and it is not published anywhere, or it is not one has not applied for the grant of patent, then in that situation, the art prior art here means that it is known to the public. If somewhere anybody knows about your invention, then that is sufficient for protection of your patent. Then you have to mention that prior art. Then who is the inventor? But obvious, it is mandatory to mention about the details of the inventor, who has done that particular invention, the name, the age, the occupation, XYZ, all has to be mentioned in that particular document. And when and where the application for a patent was filed, if someone has filed the patent application in some other jurisdiction or somewhere else, it may be rejected or pending. So you have to mention that also, and the name and address of the inventor. So all these are the information which has to be furnished for the grant of information and while applying for the patent. Now these are the basic steps which are involved for the registration of the patent or for the grant of the patent. So first step is the patent search. Before applying for the patent, you have to first of all search whether this kind of invention has been already patented or not. You can apply for a particular patent only if that particular invention is not patented. So this is very important. So first of all, you have to search for the patent from different websites. Websites are available. Okay, in India we have website that is ipoindia.gov.in. So you can go there and you can search for the particular patent. As you all know that if it is already patented, means it is not an invention at all. So even if you apply, the patent office may reject your invention for the purpose of patenting. Then next is drafting patent specification. This is also mandatory requirement that you have to draft the specification along with the patent application for the purpose of grant of patent. Then patent application filing. After you have prepared the patent document and you have prepared the specification document, then you can go for the application filing. And this application filing is not an offline process, it is an online process. Through website you can apply for the particular patent. And the Government of India, the Patent Office, it motivates the online application, as there are so many objectives like to avoid to promote paperless work and some other things. And experience work, transparency. So there are so many aspects. So because of all these reasons, the Government of India promotes and it appreciates the filing of application on online mode. Then after the application is made, then after a particular period of time, the patent publication is done by the patent office so that the people can get the knowledge about the particular patent. And after that, requesting after the publication, then the inventor can request for the examination of the patent. And lastly, when the Indian Patent Office is satisfied, when the Controller General of Patent, Design and Trademark is satisfied, and there is no objection from any person, from anybody in this society, then finally the patent is granted. So these are the steps. Now we will discuss in detail. See friends, here is the diagram, flow diagram for the grant of patent. So what is the first step? First, we can see that first patent is filing of the patent. Then what happens? Along with that, you have to file the patent specification, complete specification, and then publication will be done after the specification is submitted. This publication is done by the Indian Patent Office for the knowledge to the public that this particular invention is being made. And another purpose is if anybody has already got similar patent, then that person can take objection, or in case if the patent is not as per the public policy, if it is immoral, if it is illegal, if it is not supported by the public, in that case also the patent can be the people can take objection and may not be considered for the grant of the patent. So after that, pre-grant opposition means before granting, if any opposition is required, then if there is no opposition, if nobody is taking any objection, if it is okay, some time is given, then the inventor can request for the examination. And Form 18 is required for the expedited examination. So if you want that examination has to be done early, then by paying the prescribed fees, you can ask the patent office for the speedy examination. Then after this, the examination for patentability and other requirements are to be fulfilled, and after fulfilling the requirement, after the patent office is satisfied, then the FER is issued. FER stands for first examination report is issued, and finally then the application is to put in order to by the applicant within 6 months, and if any objection is taken, then again if some point is not clear, or the patent office wants some more clarification on a particular aspect with the invention, then it has to be satisfied. The inventor has to satisfy the particular information, and then it is heard by the Controller General, and if the objection is satisfied, then finally the patent can be granted. This objection must be met within a period of 6 to 9 months. If there is an objection is taken by the examiner of the patent, then it has to be satisfied. Sufficient time is given, 6 to 9 months, and then if it is okay, then the patent is granted under section 43 and it is published. Otherwise, if the objections are not met within this time limit of 6 to 9 months, then it is deemed to be abandoned. So this is the process for entire grant of patent. And so friends, here we have seen if the things are going smoothly, but the situation may arise that at the time of filing of the application, the inventor is not ready with the provisional with the specification. Then in that case, it can submit the provisional specification, and within a period of specific time. And if it is not able to produce the final specification, then the application will be rejected or it will be deemed to be abandoned. So this is the entire flow chart of the grant of patent. So all these things, whatever we have discussed in that particular diagram, is being explained over here. So first step, as I told you, patent application. The patent application is the request. What is actually patent application? Is the request which is made to the patent office for grant of patent by the inventor. Then direct filing. So if the inventor is ready with the specification, then the person can file the application for the grant of payment, and then subsequent filing, if in case the patent holder, the inventor is not ready with the specification, then it can go for filing the provisional specification. So filing of a patent application in India Patent Office is the first step towards the securing patent to your invention in India. And after this, you can see that certain forms, certain documents, certain specimens are prescribed by the government that has to be provided along with the specification. That is form number 1, 2, 3 and 5 has to be submitted to the patent office and should be filled for innovative research and development work only. If it is research and development work, then these forms are need to be completed. Then subsequently to filing these forms with the appropriate fees, you will receive a patent application number from the patent office. After you have completed all these formalities, you have paid the fees, then you will get a number, and this number you can check it on the website. Patent office provides facility to file a patent application online. As I earlier told you that Government of India Patent Office promotes online application due to various reasons, as we have just discussed. Alternatively, one can file patent application in hard copy also to the patent office, and the patent office is located in Delhi, Calcutta, Mumbai and Chennai. These are the 4 headquarters of patent office, and whosoever come in that particular jurisdiction, they have to approach to these various cities in India. But since the Government of India want to discourage the hard offline application, so it charges 10% additional fees if somebody is applying through hard copies or offline mode. So friends, so in case of 4 inventions, if the invention is maturing stage, we have the option to file the provisional patent application, and after that we can file complete patent specification within 12 months and the date of filing for provisional application. After filing the patent application, it is published after 18 months from the date of first filing. So this is very important that it is published by the patent journal, published in the patent journal, so that the public can get the knowledge, get the awareness about such invention, and it gives them the opportunity of taking any opposition, of taking any kind of objection related to that particular invention. If you want to expedite our patent protection, then we have to place a request for early publication with the help of form number 9. We have to fill a form number 9, if we want that our patent must be published within that particular time. Next step would be the filing the request for examination. After the publication is done, we receive a patent number. Then we can ask the examiner, we can apply to the examiner for examination of the patent by using form number 18, and this will help the patent office whether the patent is eligible to be granted or not granted. During the patent prosecution, the examiner submits the examination report. The inventor has to analyze the report to respond to the examination report. If any question is asked, if any doubt arises, if any kind of you can see if any kind of query is there, then you have to satisfy to the examiner regarding that particular invention. After meeting the objection raised by the examiner, the application would be placed, order, and grant would be notified in the patent journal. So friends, here the documents to be submitted along with the patent application. These are the documents we have already discussed. Now here, if suppose if the inventor is not having any professional, the inventor is not able to apply, then it can take the help of the agent also. Nowadays, agents are there who can file patent on behalf of the inventor because they are getting they are giving professional services pertaining to that particular work. So you can also do that for through power of attorney, through the patent agent, and declaration of invention. And you are also supposed to pay the fees either through cash or check or demand draft. So friends, these are the forms which are described here. So these forms has to be submitted for the grant of the patent in the entire process. So form number one, that is application for grant of patent. So form, you have to fill form number one. Then form number two is for provisional and complete specification. Then form number three is for the purpose of statement and undertaking under section 8. Form number 5 for declaration as to inventorship. Form number 9, request for the publication, and form number 18 for the request of examination of the application of the patent. So these are the various forms for the application of patent. So I will not go into much detail as this is, I think, we can skip this because this is quite technical, and at this point of time, I don't think that this needs to be discussed. You must have a clear general idea about what are the different forms meant for. Now this is about the fees for the various for the application of the payment. So we have form number one, that is, as you know, it is for the purpose of application for the patent. So if the applicant is a natural person like you and me, then the fees is 1600. And if it is a business entity, if it is an artificial person, then if it is a small entity, then the fees will be 4000 rupees. And other except small entities, if it is a big entity, then the fees will be double of what it is charged for the small entities, that is rupees 8000. And for form number 2, 3, 4, 5, there is no extra fees charged. For form number 9, you have to pay 2500 rupees if you are a person. If it is related to an individual, that's per person. Then for small entities, it is 6250, and for other than small entities, it is 12,500 rupees. And form 18, as you know, it is for the request for examination, and if it is a natural person, then it is 4,000 rupees. For small entities, 10,000 rupees. For large entities, 20,000 rupees. So this is the fees which has to be paid to the patent office for the grant of the patent. So a fee of 160, 400, 800 based on the type of the applicant is applicable for each sheet exceeding 30 sheets in the patent specification. Now, one more important thing, that if you are having 160 sheets, you have to submit the specification also along with the application. So if it consists 160 sheets, then the fee if it exceeds 30 sheets, then fees is 160. Then if some more sheets, then 400, 800 will be charged depending upon the number of sheets. Then further fees of rupees 320, 800, 1600 based on the type of application is applicable to each claim exceeding 10 claims in the patent specification. So as per the claims also, as the number of claims goes on increasing, the charges are also higher. So friends, this we have discussed yesterday. On the basis of application, there are different types of patent applications, that is provisional application, ordinary or provisional application, non-provisional application, convention application, PCT international application, DCT national phase application, patent of addition, and divisional patent. This all we have discussed in yesterday lecture, so I will not continue with all these slides. Now, what is required? What do we mean by complete specification? So first thing is the specification must contain the title. What is the title of your patent? Like machine for food slicing, or machine for vegetable slicing. Like whatever invention is done, that will be the title. The technical field of the invention means the area to which your technique belongs, objects of the invention, background of the invention, statement of the invention, brief description of the drawings. You have to attach the drawings also along with the patent application in your specification, a detailed description of the invention, claims, what claims are made, the abstract and preamble of the invention. So these are the minimum requirements which has to be fulfilled in a specification. So this is about the convention application. This we have discussed earlier. I will not repeat it. So friends, this is the official website of Indian Patent Office, Government of India, that is ipoindia.gov.in. So here you can see if you want to apply for a patent, here you can find out how you will get the application form, and whatever is asked, you can fill it up and submit the form. And here only you will get the application number and the status of your application. All these details you will get here. Then designs also, if you want to apply for designs, again you have to go on the same website. For trademarks also, and for GI too. So these are the various intellectual properties for which you have to visit a common site, that is ipoindia.gov.in. This is how it looks. Now these are the territorial jurisdiction for appropriate office for the applicants. There are major 4 offices located in Mumbai, Chennai, New Delhi and Calcutta. So under Mumbai, states of Maharashtra, Gujarat, Madhya Pradesh, Goa, Chhattisgarh and Union Territories, Daman and Diu, Nagar Haveli, all these states has to apply for the patent in Mumbai jurisdiction. Then patent office branch located in Chennai. Here the states of Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, Telangana and Union Territories of Pondicherry and Lakshadweep. These states has to apply in this particular territory. And New Delhi, so states of Haryana, Himachal Pradesh, Punjab, Rajasthan, Uttar Pradesh, Uttarakhand, Delhi and Union Territory of Chandigarh and Jammu and Kashmir, Ladakh. All these states has to make the application under the New Delhi jurisdiction, and rest of the states which are not mentioned in either of these categories, so they have to apply to the jurisdiction of Calcutta.